So hello guys, welcome to Sandpaper-Academy for Civil Services prelims examination karone aru complete ekmah ase because aji hol 16th aru 17th juntu March hoy aji 16 February pra 16 March hole apunar 1 month aru 17 March hot apunar tentative juntu prelims or date dise etu hobole goi ase gotike ami jotu first phase of hoisilu polity first 30 ta aji ami next 50 টা question লৈ আহিছো MCQ যেটো আমাৰ ৰিভাইজ উইথ MCQ মাৰাথন সিৰিজৰ আন্ডাৰত আছে আৰু ইয়াৰ পিছতো পাৰ্ট 3 আহিব সো আজি পাৰ্ট 2 সো সময় নষ্ট নকৰি আমি বিগিন কৰো ওকে সো first question to this the Constitution of India which was adopted on 26 November 1949 had kiman section articles asile aru keita schedule asile hudise A preamble 395 articles and 8 schedules. Option B A preamble 402 articles 8 schedules. Number C this A preamble 395 articles 12 schedules. Aru D this A preamble 402 articles 12 schedules. So ekhini homoyot jetia আমাৰ constitution খন adopt কৰিছিলে 26 November 1949 ত তেতিয়া কোনটো correct হয় so option A এটা preamble 395 টা article আৰু 8 schedule পিছত আৰু 4 টা schedule add কৰা গৈছে okay so a motion on draft constitution was declared as passed on 26 November 1949 received the signatures of all the members and the president eketa kotha janibo lage out of a total 299 members of the assembly only 284 were actually present on the day aru signed the constitution okay the constitution was adopted on 26 November 1949 contained a preamble 395 articles and 8 schedules okay so first question is over we will move to the next question expert committee ekhon গঠন কৰা গৈছিলে তাতে কি কৈছে expert committee for the purpose of preparing material for constituent assembly was appointed by Congress party that is Indian National Congress on 1946 8 July to tar member kun nasile etu hudise okay so question bilak bhalke poibo member not a member M Asaf Ali K Munshi Ketisa aru Sardar Vallabhbhai Patel so yar option ki hobo option D Vallabhbhai Patel was not the member of the expert committee okay so yar background to ki asile while election to the constituent assembly were still in progress on 8 July 1946 যেতিয়া constituent assembly election or আপোনাৰ progress হৈ আছিল তেতিয়া কংগ্ৰেছ পাৰ্টিয়ে এখন এক্সপাৰ্ট কমিটি গঠন কৰি দিছিলে যাতে মেটেৰিয়েল বিলাক প্ৰিপেয়াৰ কৰিব পৰা যায় আৰু ইয়াতে 8 জন মেম্বাৰ আছিলে ইনক্লুডিং জৱাহৰলাল নেহেৰু যিজন চেয়াৰম্যান আছিলে সো বাকি সকল আছিলে এম আসাফ আলী কে এম মুন্সি এন গোপালস্বামী আয়াঙ্গাৰ কেটি শাহ এটো 6 okay Dr. DR Gadgil Humayun Kabir and K Santhanam aru later on chairman or proposal mane Jawaharlal Nehru proposal krome aru ejonok add kora goisile je Krishna Kripalani to be co-opted as member and convener of that committee so who became the convener Krishna Kripalani okay the committee was further the committee had two sittings dubar hoisile duta sittings hoisile first 1946 or 20 July pura 22 July leke aru second sitting to hoisile 1946 ote hoisile from 15 August to 17 August so these are the important facts you should remember okay next ami go to which of the following is or are true about Constitution of India fundamental rights and directive principle of state policy derive their inspiration from American and Irish constitution respectively is it correct okay the principle of cabinet government and the relation between executive and legislature has been largely drawn from British constitution yate option dise kuntu correct one only two only both or none so if you have apnaluke Indian constitution or junkhini provisions ase ba keyword ase kor pora kun constitution or pora boro korise ekita monot rakhibo okay so yat gute keta shuddho dise Fundamental rights was from American Constitution, directive principle of state policy from Irish Constitution, cabinet government and relation between executive and legislature, British Constitution. Okay, adopt the structural part of the Constitution to a large extent derived from the Government of India. So, Government of India Act of federal schemes, judiciary, governors, emergency powers, public service commission, and most of the administrative details were drawn from 1935 Government of India Act. Okay. So, ami Government of India Act already first part of পঢ়ি আহিছিলো MCQ marathonor. I hope সকলোৱে তাতে পঢ়িছে। ঠিক আছে, the philosophical part of the constitution, that is fundamental rights, DPSP corpora anishe, American and Irish constitution. Political part of the constitution, that is cabinet government, relation between executive and legislature, ebilak corpora anishe, British constitution opra anishe. আৰু other বিভিন্ন provisions আছে Canada পৰা, Australia পৰা, Germany constitution পৰা, USSR পৰা, France, South Africa, Japan and so on. এই গুটেই কেইটাৰ পৰা কি borrow কৰিছে আপোনালোকে একবাৰ জনাব, যদি পাৰে মোক একবাৰ কমেন্ট বক্সত দি থব, যাতে কেতিয়াবা আপোনাৰ পৰীক্ষাৰ আগত পটককে কমেন্ট বক্সত চাই ললে এইটো আছিলে, আকৌ কিতাপ খুলি খুলি যাতে চাব লগা নহয়। সো আপোনালোকৰ কাৰণে কৈছো, if you can do it, it's good only. So question number 4, which of the following amendment procedure is provided by Article 368? Article 368 এ কেনেকুৱা ধৰণৰ amendment procedure দিয়ে তাকে সুধিছে। Some provision can be amended by special majority of the parliament, that is 2/3 majority of the members of each house present and voting, and the majority of total membership of each house. So কৈছে কি special majority provision to Article 368 এ দিয়ে। আৰু কৈছে স্পেচিয়েল মেজৰিটিৰ প্ৰথমটো আছিল কি ইচ হাউস অফ দা মেম্বাৰ প্ৰেজেন্ট আৰু ভোটিং থাকিব লাগিব, আৰু মেজৰিটি অফ টোটেল মেম্বাৰশিপ অফ ইচ হাউস প্ৰেজেন্ট থাকিব লাগিব। আৰু এটা স্পেচিয়েল মেজৰিটি দিয়ে বুলি কৈছে 360 তে কি উইথ দা ৰেক্টিফিকেশন অফ হাফ অফ দা টোটেল ষ্টেট। আৰু এটা কি দিয়ে বুলি কৈছে, some provisions of the constitution can be amended by simple majority of parliament in the manner of ordinary legislative process amend কৰাৰ দৰে পাৰ্লিয়ামেন্টে সিম্পল মেজৰিটিটো আন্ডাৰ আৰ্টিকল 368 এৰে এমেন্ডমেন্ট প্ৰসিডিউৰ কৰিব পাৰে বুলি কৈছে। এতিয়া আপোনালোকে যদি কেয়াৰফুলি চাই আৰ্টিকল 368 এ কেৱল 1 আৰু 2 স্পেচিয়েল মেজৰিটিৰ কথাহে উল্লেখ কৰিছে, এই সিম্পল মেজৰিটি কথা উল্লেখ কৰা নাই। গতিকে ইয়াত 1 and 2 হে শুদ্ধ হ'ব, 3 will not be correct. So D option will be correct. The Constitution of India is neither rigid or flexible, but a synthesis of both. So Article 368 provides for two types of amendment. Special majority, jot 2/3 of the each house present থাকিব, Lok Sabha আৰু Rajya Sabha, আৰু voting কৰিব, আৰু majority of total membership of each house থাকিব লাগিব। Okay, আৰু এটা mention কৰিছে, some other provisions can also be amended by special majority of parliament and with the ratification of half of the total state. ঠিক আছে, half of the total state or ratification লাগিব। এটো আমাৰ 368 ৰ আন্ডাৰত আছে। কিন্তু some provisions of constitution can be amended by simple majority of the parliament in the manner of ordinary legislative process too আছে, কিন্তু এটো under article 368 ৰ আন্ডাৰত নাহে। So very important, what is given in the question should be understand properly. Here the main keyword is article 368. Okay, next we will go to the question number 5, which of the following is not a unitary or non-federal feature of the Indian Constitution? A strong center, single constitution, division of power, single citizenship. So it is a very easy question, answer C. The Constitution of India establishes federal system of government. It contains usual features of federation, two government, division of powers, so it is federal feature under the written constitution, supremacy of constitution, rigidity of constitution, independent judiciary, bicameralism, etc. However, Indian constitution contains a large number of unitary features, unitary মানে single but non-federal features such as strong center, single constitution, single citizenship, flexibility of constitution, integrated judiciary, appointment of state governor by center, all India service, emergency of provisions, and so on. So these are unitary features. আমি আকৌ এই কোৱেশ্চনটো ৰিভাইজ কৰিম। Okay, next question number 6, Parliamentary government of feature kuntu nohoy hudise presence of nominal and real executive, member of the ministers in the membership of the members in the legislature, leadership of prime minister or the chief minister, presence of nominal and real executive. Okay, so yare kuntu feature parliamentary government or nohoy boli koise none mane guti kita hoy 1 only, 2 and 4 only, 3 only. So if you have studied properly parliamentary government chapter, then you will get to know that all of them are true. That means none are incorrect. Yate incorrect kun keta hoje not the features kintu gute keta features, therefore none. Okay, so don't get confused. The feature of parliamentary government in India are presence of nominal and real executives, majority part rule, collective responsibility of executive to the legislature, membership of minister in the legislature, leadership of prime minister or chief minister, dissolution of lower house, that means Lok Sabha or assembly. So all these are features of parliamentary government in India. Next I go to question number 7. It is of which of the following pairs are correctly matched? Kun keta correctly match hoise etu kuise. Right to equality covers from article 14 to 18, right to freedom 19 to 20, right against exploitation 25 to 28, and right to freedom of religion 23 to 24. So আপোনালোকে এই particular zone keta right ase, these are very important and basic because ebilak bahut time on question of ahi ase. Okay, so ei gute ketar article kor pora koleke to monot rakhibo lagibo. So yat apunar correct ase 1 and 2 only aru ei keta alter hoi ase. ঠিক আছে, so part 3 of Indian Constitution guaranteed 6 fundamental rights to all citizens: right to equality from 14 to 18, right to freedom 19 to 22, right against exploitation 23 to 24. এইটো question আমাৰ ভুল দি দিছিলে আৰু কি দিছিলে ম্যাচিং টো right to freedom of religion এইটো হয় 25 to 28. okay, আৰু আছে cultural and educational right 29 to 30 and right to constitutional remedies article 32. Please remember all these fundamental rights. ঠিক আছে, next আমি আহি গৈছো which of the following is not correct. Ako kudise not correct. Correct kuntu nohoy. Fundamental rights are meant for promoting the idea of political democracy. They are justiciable in nature, that is they are enforceable by the courts for their violation. They are not sacrosanct and can be curtailed and replaced by the parliament through constitutional amendment act. They can also be suspended during the operation of a national emergency except rights guaranteed by article 20 and 21. So yate jodi apni koy kun keta option true kuntu option correct nohoy hetu hudise. So all options are true here, that means none are incorrect. ঠিক আছে, the fundamental rights mean for political democracy karone fundamental rights bilak enek kora goisile. They operate as limitation on tyranny of executive and arbitrary laws of legislature. Ebilor pora je manuok precaution dibo karone these are justifiable in nature, that is they are enforceable by the courts. Jodi violation hoy we can go to the court. The aggrieved person can directly go to the Supreme Court, which can issue writs. Jodi Supreme Court jai, Supreme Court habeas corpus, mandamus, prohibition, certiorari and quo and pasta writs ase he keta proyog koribo pare. However, the fundamental rights are not absolute and subjected to be reasonable restriction. Etu eta kotha. Further, they are not sacrosanct and can be curtailed or repealed by a parliament through constitutional amendment act. Very important, very important. A line to monot rakhibo. Okay, so they are not sacrosanct, they can be curtailed or replaced by the parliament through constitutional amendment act. So aru ki they can be also suspended during national emergency. Etu gome pai national emergency fundamental right keta curtail hoy mane ki hoy jay suspend হৈ যায় except দুটা কিন্তু article 20 and article 21 so article 20 কি হয় আৰু article 21 কি হয় মোক কমেন্ট বক্সত জনাওক আৰু এই কোৱেশ্চনটো যদি অপচনেলত আহে during the emergency operation which of the following two rights remain as it is for fundamental rights remain as it is but not suspended তেতিয়া আপোনালোকে লিখিব লাগিব article 20 and article 21 আৰু কেতিয়াবা আপোনালোকক সেন্টেন্সৰ থ্ৰুও দিব পাৰে যে right to life and property এনেকে কিছুমান দিব পাৰে তো গটিকে আপোনালোকে 20 আৰু 21 এ কি বুজায় সেটো মনত ৰাখিব লাগিব দ্যাটস ওয়াই মই আপোনালোকক কমেন্ট বক্সত দিব কৈছো নেক্সট question number 9 in which of the following case the Supreme Court held that the Indian Constitution is founded on the bedrock of balance between fundamental rights and the directive principles so আপোনালোকে যি সকলে fundamental rights preamble এই কেস কেটা লৈ পেলাই যোন কেটা judgment আহিছে please revise before exam नहीं तो minus हो जाएगा ठीक है सर so केशवानंद भारती केस गोलकनाथ केस आयर कहेलू केस व मिनर्वा मिल्स केस so the correct option will be D minerva mills case okay directive principle of state policy kotha ketaman koi do they are enumerated in part 4 of Indian Constitution covers article 36 to 51 এ কি কৰে কিয় কাৰণে মানে এই provision to আনা হল promoting the ideal of social and economic democracy so they represent ideal of বা promotes ideal of social and economic democracy আৰু এইটো question আগৰ দিনৰ MCQ বিলাকত আহিছিল still it represents or it seeks to establish welfare state in India. However, unlike fundamental right, they are non-justiciable in nature. So, তেওঁলোকৰ violationৰ কাৰণে আমি কোৰ্টত যাব নোৱাৰো ঠিক আছে yet the constitution itself declares that these principles are fundamental তথাপিতো constitution কৈছে যে they are fundamental মানে এইখিনি governance ত এই directive principle of state policy খিনি গটিকে জৰুৰী বা ফান্ডামেন্টাল হয় এইখিনি গটিকে স্টেটে যেতিয়া ল বা কিবা বনাই তেতিয়া হলে it shall be the duty of state to apply these principles in making law বুজি পাইছে নে hence they impose a moral obligation on state authorities for their application so moral application state authority during law making process কোনে provide কৰে directive principle of state policy next we will go to the question number 10 okay etu dangor hoy goise which of the following about fundamental duties are not correct fundamental duty kuntu correct hoy hetu hudise the original constitution did not provide the fundamental duties for citizens definitely so 11 fundamental duties for citizens were added by 42nd constitutional amendment act of 1976 on recommendation of Swaran Singh committee etu huddo korise kintu kotha to hol ki 11 ta asil janu by 42nd constitutional amendment act yate option 1 is correct only 10 fundamental duties were added okay and 86 constitutional amendment act 2002 আৰু এটা 11 নম্বৰটো এড কৰিছিল এতিয়া এই 86th constitutional amendment act ए কোনটো fundamental duty add কৰিছিল comment box में मुझे बताओ okay so fundamental duty কথা কৈছো 51 এ part 4 এ কিহৰ লগত ডিল কৰে fundamental duty original constitution এ provide কৰা নাছিলে fundamental duty যে থাকিব লাগে these were added during the operation of internal emergency and by 42nd constitutional amendment act on recommendation of Swaran Singh committee please এই নামটো মনত ৰাখিব Swaran Singh committee important this is related to the fundamental duty আৰু এটা মোক ক'ব পাৰিবনে fundamental duty লগত জড়িত committee have you heard about Verma committee এটো কি হয় মোক এবাৰ জনাবচোন কমেন্ট বক্সত okay ঠিক আছে So part 4A of constitution, which consists of only article 51A, specifies 11 fundamental duties right now. ঠিক আছে, next the fundamental duty বিলাকৰ আৰু দুটামান property কৈ দিছো, they serve as a reminder to citizens that while enjoying their right, তোমালোকেটো fundamental right বিলাক enjoy কৰি আছা, আমাৰো কিছুমান মানে duty আছে for our own motherland, our society and to other fellow citizens. So এইবিলাক fundamental duty under ঠিক আছে. However, like directive principle of state policy, these duties are non-justiciable in nature. বুজি পাইছে নে? Non-justiciable কি হয়? DPSP and fundamental duty, আৰু justiciable কি হয়? Fundamental right. Okay. Next, we are going to the question number 11. Which article of Indian Constitution states all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate any religion? This article is also very, very important. So, if you have studied properly the important articles, then you will get to know that option D is correct. Okay. আৰু ইয়াৰ লগত জড়িত কেইটামান বহুত ইম্পৰ্টেন্ট কথা আপোনালোকে নোট কৰি ল'ব। Term secular was added to the preamble of Indian Constitution by 42nd Constitutional Amendment Act 1976. Ako, the preamble secures to all citizens of India liberty of belief, faith and worship. The states shall not deny to any person equality before law and equal protection of laws under Article 14. Aru state shall not discriminate against any citizens on the ground of in religion. Eto article 15 e diye. So article 14 e ki bujay etu di disu moi, article 15 e ki bujay etu di disu. Article 16 e ki bujay? Equal opportunity for all citizens in matters of public employment. 14 e bujay state e konuba personor equality before law aru equal protection before law to deny koribo nware if he is a citizen of India. Article 15 e বুজায় কি স্টেটে কিতিয়াও এজন সিটিজেনক ৰিলিজনৰ বেসিছত ডিসক্ৰিমিনেট কৰিব নোৱাৰে, আৰু আৰ্টিকল 16 এ বুজায় প্ৰত্যেকজন সিটিজেনক পাবলিক এমপ্লয়মেন্টৰ ক্ষেত্ৰত ইকুৱেল অপৰচুনিটি দিব। ঠিক আছে, আৰু আৰ্টিকল 25 এ বুজায় all persons equally entitled to freedom of conscience and right to freely profess, practice and propagate any religion. Okay, so next I go article question number 12. So which of the following constitutional amendment act reduce voting junto age ase 18 বছৰ আগতে আছিল 21 বছৰ, কোনখনে reduce কৰি 18 বছৰ কৰিলে? 42nd constitutional amendment act, 44th constitutional amendment act, 61st constitutional amendment act, 86th constitutional amendment act 2002. So the correct answer is C, 61st constitutional amendment act. 61st constitutional amendment act. So Indian Constitution adopts universal adult franchise on the basis of elections to Lok Sabha and state legislative assemblies. Every citizen who is not less than 18 years has the right to vote. ঠিক আছে, আৰু a voting was reduced from 18 to 21 in the year 1989 not reduce হৈছিলে, যদি year খুধে 1989, আৰু যোনখন amendment act আছে এখন হল 61st constitutional amendment act 1988. এতিয়া কিস্তিবা কি হয় দুখন এক ইয়াৰ বাহিৰেও কেইটামান এক বহুতে ইম্পৰ্টেন্ট CAS বা কনস্টিটিউশনাল এমেন্ডমেন্ট এক্ট, এটা হল 42nd আৰু 44th. যেতিয়া মেইনছত লিখিব উদাহৰণ দিব লগা হলে কেতিয়াবা ৰাইজে পাহৰি যায় যে 42nd কনস্টিটিউশনাল এমেন্ডমেন্ট এক্ট আমি পাহৰা যায় যে কিমান চনত হৈছিল। সো বেসিক্যালি এটো মনত ৰাখিব কাৰণে আপোনালোকে ইউ ডু ওয়ান থিং, দিস প্লাস ইট 6 हो गया ना, बाकी केटा खाली মনত ৰাখিব 1976 আৰু 44 টো মই হেনেকে দি দিছো। 44 ত বেছি একো কৰিব নালাগে, 4 + 4 কৰি দিব 8, সো আগত সেম 197 লগাই দিলে হ'ল, 1976 আৰু 1970। ওকে, আৰু নেক্সট আমি আহি যাও কোৱেশ্চন নম্বৰ 13. Which of the following constitutional amendment act gave a constitutional status and protection to cooperative society? So cooperative society কোনখনে constitutional status আৰু protection দিছে? So question option A will be correct here. So 2011 ত যোনখন আহিছিলে constitutional amendment act 97th number, so it provides a constitutional status and protection to cooperative society. Okay, so in this context it made following 3 changes in the constitution. তিনটা চেঞ্জ কৰিছিলে কি কি it made a right to form cooperative societies a fundamental right under article 19 very important it included a new DPSP on promotion of cooperative society which covered from article 4 which covered on the article 43b আৰু কি এড কৰিছিলে part 9b of Indian Constitution which is entitled as the cooperative societies and it covers article from 243z to 243z3 please remember please okay panchayat municipality cooperative society these things should be remembered kune add korisile kiba part add hoisile niki kiba schedule add hoisile niki kimanor pra kiman article cover hoisile kihot monot rakhibo panchayatot monot rakhibo municipality monot rakhibo cooperative society monot rakhibo আজিয়ে লিখি থবৰ লগত এতিয়া পঢ়াৰ লগত ৰাতিকে চাই দিম okay next which of the following is correctly matched কোনটো correctly match আছে fourth schedule তে কি কৈছে allocation of seats in Rajya Sabha to the states and union territories fifth schedule ki kaise provisions related to the administration and control of scheduled areas and scheduled tribes okay sixth schedule ki kaise AMTM ta mane Assam Meghalaya Tripura aru Mizoramor administration or kotha bujaise tribal area seventh schedule language recognized by constitution kaise this cannot be true this should be eighth okay so here 1 2 and 3 are correctly matched okay eighth schedule bujaise language or kotha okay etu jontu dise this should be 8th schedule etu dise aru ei jontu 7th schedule ki bujay division of powers between union and the states in terms of list ki ase amar union list state list and concurrent list jetia center e eta list eta kisuman subject or uporot nijor law making power ase kebilak union list ot thakibo jun bilakot state or power ase only kebilak thakibo state list আৰু both যেতিয়া center আৰু state দুইটাৰে আছে তেতিয়া হেবিলাক কোন লিষ্টত থাকিব concurrent লিষ্টত থাকিব okay next আমি গুছি যাম 15 number which of the following is correctly matched 1935 ৰ কথা কৈছে parliamentary government ৰ কথা আছে british constitution ৰ পৰা আহিছে public service commission US constitution ৰ পৰা আহিছে judicial review and Irish constitution ৰ পৰা আহিছে directive principle of state policy so ইয়াৰ ভিতৰত অপশনত যদি চাই তেতিয়া হলে গমে পাব কি কোনবা নহয় কোনবাটো তো কারেক্টলি ম্যাচ হৈ থাকাই নাই বিকজ ইয়াতে 1 2 3 4 বুলি তো অপশন নাই গটিকে আপনি যদি চাই হিয়ার 1 and 2 are not correctly matched that is 3 and 4 are correctly matched so government of India যদি চাই public service commission এটু দিয়া আছে British constitution আর parliamentary government তো দিয়া আছে Government of India Act against jun keta bhul hoy ase gotike Government of India Act ketaman important feature moi di disu federal scheme office of government judiciary public service commissions emergency provision administrative details beleg upay nai eketa monot rakhibo lagibo important hoy British constitution or tanike parliamentary government rule of law eketa bahut important fact hoy tanike cabinet system also এইকেইটা মান আপোনালোকে মনত ৰাখিব লাগে তেনেকে US কনস্টিটিউচনৰ খুব ইম্পৰ্টেন্ট বস্তু ফান্ডামেন্টাল ৰাইট ইন্ডিপেন্ডেন্ট জুডিচিয়াৰি জুডিচিয়াল ৰিভিউ আৰু আপোনাৰ a post of vice president এইকেইটা কোৱেশ্চন মই বহুত আহা দেখা পাইছো আৰু আইৰিছ কনস্টিটিউচনৰ ডাইৰেক্টিভ প্ৰিন্সিপল অফ ষ্টেট পলিচি এইকেইটা মানে আছে এইকেইটা মনত ৰাখি লব নমিনেশন অফ মেম্বাৰ্স টু ৰাজ্য সভা আৰু মেথড অফ ইলেকশন অফ প্ৰেসিডেন্ট very important Okay, we will go to the next question. Which of the following is or are not true, not true about preamble of Indian Constitution? So the preamble of Indian Constitution is based on objective resolution. Is it correct? 100% correct. It is it has been amended by 42nd Constitutional Amendment Act 1976. This is also correct. That means not true mane ki none is not true. Option D is correct. আৰু এই 42nd Constitutional Amendment Act তিনটা বস্তু এড কৰিছিলে সেকুলাৰ সোশিয়ালিষ্ট এন্ড ইন্টিগ্ৰিটি মনত ৰাখিব ওকে N.A. Palkhiwala an eminent jurist and constitutional expert preamble to কি বুলি কৈছিলে identity card of constitution এই ৰিমাৰ্কটো কোনে কৈছিল বুলি যদি কেতিয়াবা আহে তেতিয়া হলে কি লিখিব N.A. Palkhiwala Aru, it is based on objective resolution. The preamble of India is based on objective resolution drafted and moved by Pandit Nehru and adopted by the Constitutional Assembly. Okay. So the is preamble amendable? Amend कर सकते हैं? Already हो चुका है. But you cannot modify basic structure. যদি প্ৰিএম্বুলত থকা কিছুমান কথাই বেসিক স্ট্রাকচার অফ কনস্টিটিউশন মিন কৰিছে you cannot amend those things. Very important. আৰু এটো কোনটো জাজমেন্টত কৈছিলে কমেন্ট বক্স মে মুझे बताओ. Next, প্ৰিএম্বুলৰ কেটামান চাৰিটা ইনগ্ৰেডিয়েন্টস আছে একেটাও মনত ৰাখি দিব. Source of authority of the constitution, প্ৰিএম্বুলৰ components. The preamble states that constitution derives its authority from people of India. Nature of Indian state preamble represent করে তার মানে he declares India to be a sovereign, socialist, secular, democratic and republican polity. Okay, objective of the constitution we specify করে, it specifies justice, liberty, equality, fraternity as the objectives. Fraternity means brotherhood. Okay, date of adoption of constitution or kothao year component of it or that is 26 November 1949 as the date. Okay, next we are going to the question number 19. Kuntu correctly match ase hetu hudha na yat kutse match the following, that means tumi sabo lagibo je match properly ase na nai. Equality before law article 14. Okay, equal opportunity, equality of opportunity by equal opportunity in matters of public employment article 15. Prohibition on discrimination on the grounds of caste, religion, race or place of birth. Abolition of untouchability article 17 and abolition of titles, that is article 18. So if you have gone through all these important articles, then you will get to know that option 2 is wrongly matched with this and this should be this. Okay, so one should be equality before law is article 14. Prohibition in discrimination on the grounds of race, religion, caste, sex, place of birth comes under article 15. Equal opportunity in matters of public employment comes under article 16. Abolition of untouchability under article 17. Abolition of titles comes under article 18. Okay, which of the following is true about preamble of Indian constitution? Preamble of the preamble is neither source of power to legislation nor a prohibition upon powers of legislation. Very true. It is non-justiciable, that is the provisions are not enforceable in the court of law. 1, 2, both or none. So here both are true. Very important. Okay, 19. The Supreme Court held that preamble is not a part of constitution in which of the following cases? So Berubari, Unni Krishnan, Minerva Mills case, Sunil Batra, Delhi government. So this is in Berubari Union case. So in Berubari Union case, Supreme Court held that preamble is not a part of constitution of India. Our 1960 days judgment to dia goisile. However, in Kesavananda Bharati case, Supreme Court rejected the earlier opinion and held that preamble is part of the constitution. Very important. And ebarer karone Kesavananda Bharati case to bhalke poribo. 1973 2023 pora 1973 minus korile kiman bosor hoy, how many years? That's why this is important this year. Okay, this is 2024. That questions, if questions are set from current affairs or the newses from 2023, then Keshavananda Bharati case is very important. Okay, it observed that preamble is an extreme importance and constitutions should be read and interpreted in the light of grand and noble vision expressed in the preamble. Okay, in LIC case also 1995 junto LIC case asile hetu Supreme Court again kole je preamble is an integrated part of the constitution. So we got to know two such judgment of Supreme Court where it is explicitly mentioned that preamble is a integral part of the constitution. Keswananda Bharati case and LIC case of 1995. Okay, so next we are going to Which of the following constitution deals with which of the following articles of Indian Constitution deals with internal readjustment or interstay of the territories of the constituent states of the Union of India? Bohute etu article 3 আৰু 2 মাজত কনফিউজ কৰে, গটিকে it should be article 3. article 2 এ কি কৈছে? admission or establishment of new states আৰু that were not a part of India. Okay, আৰু article 3 এ কি কৈছে? relates to the formation or changes in the existing state. This is the difference. New or existing. Re শব্দটো সেইকাৰণে আহিছে re, otherwise it should be new. Re means existing. Exist কৰিলে re কৰিব পাৰিম. In other words, article 3 deals with internal readjustment interstate of the territories of the constituent states of India. Next, we are going to the question number 21. Which of the following is true? Article 3 authorizes Parliament to form a new state by separation of territory from any state or by uniting two or more states or parts of states by uniting territory or any other part. In such case, a bill contemplating the above charges can be introduced in state legislature only on the prior recommendation of governor, and before recommending the bill, the governor has to refer the same to the chief minister of the state. It will bhul hoise because option 1 is true only. Why it is etu article 3 to sai lobo bhalke de, form a new state by separation of territory from any state. Already existing thaka kiba state or pora notun state ekhon separate kori pelai ana ba dukhon state unite kori ekhon kora or ba ekhonotke beshi state kora or different parts of the state kora, ebilak article 3 under pore. Ba increase the area of the state, diminish the area of the state, alter the boundary of the state, alter the name of the state, these are under article 3. So এই গুটেখিনি করুতে এই বিলখন কি কৰিব লাগিব? স্টেট লেজিসলেচার নহয়, পার্লামেন্টত ইন্ট্রোডিউস কৰিব লাগিব, নট স্টেট লেজিসলেচার. ওকে, আৰু এই ৰিকমেন্ডেশন টু গভৰ্ণৰৰ নহয়, প্ৰেসিডেন্ট লাগিব. আৰু প্ৰেসিডেন্টে এইটো পোৱাৰ পিছত এখন কি কৰিব? স্টেট লেজিসলেচাৰত পঠাই দিব. সাপোজ এই প্ৰপোজালটো আহিছিল অসমৰ পৰা, হি উইল সেন্ড ইট টু দা স্টেট লেজিসলেচার অফ আসাম. ঠিক আছে, কাৰণ আপোনালোকে এটা ভিউ দিয়ক যে আপোনালোকে ইয়াৰ পৰা কি আপোনালোকৰ মতামত কি এইটোৰ ওপৰত. তাৰ পিছত তেওঁলোকে যে মতামত দিলে কি আমি পাৰো বা এইটো কৰিব নোৱাৰে, কিন্তু that advice is not bound. যে প্ৰেসিডেন্টে যে এইটো মানি ল'ব লাগিব সেনেকুৱা কথা নাই, এইটো ইম্পৰ্টেন্ট কথা, এইটো নোট কৰি ল'ব. চাওক, the president or the parliament, president to ultimately parliament to দিব না, parliament is not bound by the views of the state legislature and may either accept or reject them, or even if the views are received in that time. Jodi jikue view pauk, he view to accept to koribo pare, reject to koribo pare. Okay, so suppose center e kole ki ami ekhon state or naam holoni kori amuk korim, pothai dile president or tat, president e pothai dile state legislature tat, state legislature ki koile apotti janaleo bole for center akubus ki naam to change hoboi. To স্টেট লেজিসলেচার যদি কয়ও যে আমি নামটো চেঞ্জ কৰিব নিবিচাৰো, হেতুৰ ওপৰত বাউন্ড নহয়, তাৰ মানে হেতু যে মানি ল'ব লাগিব, হেতুৰ ওপৰত কোনো ধৰণৰ মানে কিবা নাই, বাউন্ড নহয় হেতু. ওকে, ইন কেস অফ, কিন্তু আৰু এটা ইম্পৰ্টেন্ট কথা, হেতু বাৰু ষ্টেটৰ ক্ষেত্ৰত হৈ গ'ল, ইউনিয়ন টেৰিটৰীৰ ক্ষেত্ৰত কি হ'ল? নো ৰেফাৰেন্স নিড টু বি মেড টু দা কনসার্নড legislature to ascertain its views. The parliament can itself take any action as deems fit. পার্লামেন্টে নিজে ডিসিশন ল'ব লাগে পাৰে in case of union territories. Legislature কোঠাৰ প্ৰয়োজন, very important. Next আমি 22 number question গুছি গৈছো. Who was the chairman of first linguistic provinces commission set up by government of India in 1948? এটো নাম বিৰাটে মনত ৰাখিব. On the basis of language, যেতিয়া আন্দোলন হৈছিল যে বেলেগ বেলেগ স্টেট সেপাৰেশন কৰি পেলাই ক্ৰিয়েট, বেলেগ এখন স্টেট সেপাৰেশন কৰি পেলাই ক্ৰিয়েট কৰি দিব লাগে, তেতিয়া এখন কমিশন এপইন্ট কৰা গৈছিলে, যাক হেড কৰিছিলে এসকে ধৰ আৰু সেকেন্ড ফাজাল আলী. সো এসকে ধৰ ইজ ফাৰ্স্ট. Why? আমি পঢ়িম. So the integration of India independence or pisor kotha etu, the integration of princely states with rest of India has purely an ad hoc arrangement. There has been a demand from different region, bahut region or demand aise, particularly South Indian region for reorganization of state on linguistic basis, language কোৱাৰ ওপৰত তামিল কয় কিছু কলে তেলেগু কয় হয় না, different so accordingly 1948 government of India এখন linguistic provinces commission appoint কৰি দিলে under chairmanship of SK Dhar. এটো কিমান ফিজিবল ল্যাঙ্গুৱেজৰ ওপৰত ভিত্তি কৰি ষ্টেট ক্ৰিয়েট কৰাটো চাব কাৰণে কমিশনে 1948 ত ৰিপৰ্ট দিলে আৰু ৰিপৰ্টটোত কি ক'লে ৰিকগনিশন অফ ষ্টেট শুড বি অন দা বেচিস অফ এডমিনিষ্ট্ৰেটিভ কনভিনিয়েন্সৰ ওপৰত বেস কৰি পেলাইহে ষ্টেট আপোনালোকে ফৰ্ম কৰক rather than linguistic factor, rather than বুলি মেনশন কৰিছে, ৰিজেক্টটো কৰা নাই, rather than linguistic factor. It created mass resentment, অলপ অশান্তিৰ সৃষ্টি কৰিলে and led to the মানে নাৰাজগীৰ সৃষ্টি কৰিলে, led to the appointment of another linguistic provinces committee in 1948 আৰু এখন 1948 ত ক্ৰিয়েট কৰি দিয়া হ'ল to examine the question afresh, আকৌ নতুনকে কি ভাবে, so সেইখন JVP কমিটি বুলি কয়, এখন সেকেন্ড কমিশন, এটো 1948 ত আহিছিলে, ওকে তো সেইখনৰ মেম্বাৰ আছিলে জৱাহৰলাল নেহৰু, বল্লভভাই পেটেল আৰু পট্টাভি চিত্তাৰামায়া, সেইকাৰণে গোটেই কেইজনৰ নামৰ প্ৰথম লেটাৰ কেইটা লৈ JVP কমিটি বুলি ক'লে, কিন্তু 1949 ত তেওঁলোকে আকৌ কি ক'লে, they formally rejected language as the basis of reorganization of state, very important, okay. So however ৰিজেক্ট কৰাৰ পিছতো কিন্তু 1953 ত কি কৰিব লগা হৈছে, মানিব লগা হৈছে, গভৰ্নমেন্ট অফ ইন্ডিয়া was forced to create first linguistic state, কি নাম আছিল, অন্ধ্ৰ প্ৰদেশ আছিল, কেনেকে, by separating Telugu speaking areas from Madras state, okay বুজিলে, this followed a prolonged popular agitation, আৰু এটো কি মানে ইমানে প্ৰেসাৰ পালে, এজিটেশন হৈছিল একদিন সময়ত, আৰু পট্টি শ্ৰীৰামুলু নামৰ এজন কংগ্ৰেছ পাৰ্সন তেওঁ হাংগাৰ ষ্ট্ৰাইক কৰি পেলাই হৈছিলে, agitation and death of Potti Siramulu আৰু যাতে সিচুৱেশন বেয়া হৈ নাযায়, but then এইটো এখন linguistic state create কৰিব লগা হৈ গল, okay. আৰু who are the other linguistic state created, other example দিব পাৰিব নেকি, আৰু কিবা ক্ৰিয়েট হৈছে নেকি, other comment boxত জনাব, with year of formation, can you tell me some name, match the following to আহিব পাৰে, এখানে কলো match the following আহিব পাৰে, okay. So who was the chairman of state recognition commission set up in 1953, okay. So state recognition commission এখনো গঠন কৰি দিয়া হৈছিলে, here option will be Fazal Ali. Why? The creation of Andhra state intensified the demand from other regions on creation of the states and linguistic basis. So government of India এখন দিয়াৰ লগে লগে বাকি সকলো ডিমান্ড কৰিলে, so 1953 3-member states recognition commission under chairmanship of Fazal Ali to re-examine the whole question to আকৌ এবাৰ দিলে, so SK Dhar commission আহিলে, JVP committee আহিলে, তাৰ পিছত আহি গল আপোনাৰ Fazal Ali commission আহি গল, যাক 3-member state recognition commission বুলিও কয়, state recognition commission, okay. So other member, আৰু এটো কোৱেশ্চন কেতিয়াবা আহে যে এই কমিশনখনৰ other which of the following is not a member of this commission, জৱাহৰলাল নেহৰু, বাল গংগাধৰ তিলক এনেকে দি দিব, so সেইবিলাক নহয় বুলি কব, হয় কোন কোন, KM Panikkar and HN Kunjru, very important, please note it down. আৰু এবাৰ কি কৰিলে, যোনটো ৰিপৰ্ট 1955 ত দিলে তেওঁলোকে একসেপ্ট কৰিলে, broadly accepted language as the basis of recognition of state, কিন্তু এটা বস্তু তেওঁলোকে ৰিজেক্ট কৰিছে কি, theory of one language one মানে one language one state মানে stateৰ কনসেপ্টটো কিন্তু বা থিওৰিটো তেওঁলোকে ৰিজেক্ট কৰিছে, although they accepted language as the basis of recognition of state, however they rejected the theory of one language one state. In view was that view to কিহৰ কাৰণে এটো কৰিলে, unity of India should be regarded as the primary consideration in any redrawing of countries political units, in case of creation of any states or removing a part of certain state and creation of new state etc. In that case যেতিয়া বিভক্ত কৰাৰ কথা আহে তেতিয়া কিন্তু এটা বস্তু কনসিডাৰেশন কৰিব লাগিব যে primary consideration কি হ'ব লাগিব, unity of India, that should be kept in mind, okay. Next 24, which of the following is not identified by Fazal Ali commission out of the 4 major factors identified কৰিছিলে that can be taken into account in any scheme of the recognition of skill. So Fazal Ali commission e 4টা factors should be taken into account বুলি কৈছে while reorganization of state. preservation of and strengthening of the unity and security of the country, this should be correct. Linguistic and cultural homogeneity should be kept in mind during recognition of the state, that is also correct. Total population of the state is not correct, etu kotha mention nai. Financial, economic and administrative consideration is also correct, so C is not correct. Okay, not taken into account boli koise. Okay, not identified, which is not identified, but which is not mentioned by. So which is the another factor? Another factor is the planning and promotion of welfare of the people in each state as well as the nation as a whole. Okay, so next we will go to the which of the following is not true about overseas citizen of India card holder. Overseas citizen of India card holder ক্ষেত্ৰত কোনটো শুদ্ধ নহয় বুলি কৈছে। এতিয়া OCI and NRI, is there any difference? If there is some difference, then please let me know in comment box. Okay, so he or she shall not be entitled to right of equality of opportunity in matters of public employment. Okay, so he is or she shall not be eligible for appointment as judges of the Supreme Court, that is also correct. He or she shall however be entitled for a registration as a voter, ekadome bhul, voter registration hoboi nware. He or she shall be entitled to such right as central government may specify in this behalf. Okay, central government jodi kiba decide kore, then he or she will be entitled. Okay, so C is not correct. So OCI karone keitaman right nai, etu ami sai lom. An overseas citizen of India card holder shall be entitled to such rights as the central government may specify on this behalf. Central government of power আছে তেওঁলোকক কি কি রাইট দিব কি কি নিদিয়ে। ওকে, সো এইকেইটা তলৰ ফলোইং ৰাইট হয় যিকেইটা OCI এন্টাইটেল নহয়। He shall not be, he or she লগাই ল'ব, shall not be entitled to the right of equality of opportunity in matter of public employment. Election as a vice president হ'ব নোৱাৰে, election vice president হ'ব নোৱাৰে, president হ'ব নোৱাৰে, supreme courtৰ judge appointment হ'ব নোৱাৰে, judge of high court হ'ব নোৱাৰে, voter registration হ'ব নোৱাৰে, House of People or Council of State, that is member of Parliament hobo nware, member of State Legislative Assembly বা Legislative Council hobo nware, তাৰপিছত Public Service বা Affairs of Union of State বা State accept appointment in services and post as central government specify এইকেইটা তাৰ মানে তেওঁলোকে eligible নহয়, মনত ৰাখিব। নেক্সট এনেকুৱা কিছুমান ফেক্ট আহে বা কথা আহে যেতিয়া registration OCI registration to cancel হয়। Okay, so কোনটো ইয়াৰ ৰিগাৰ্ডিং ট্ৰু নহয় হৈছে, if it is satisfied that the overseas citizen of India card holder has during any war in which India may be engaged unlawfully traded or communicated with enemy, তেতিয়া তেওঁ OCI খন cancel হ'ব পাৰে, this is right. If it is satisfied that the overseas citizens of India card holder has shown these affections toward Constitution of India, that is also right. That means both are correct, that means none are not true, that is C is ঠিক আছে। ইয়াৰ কেইটামান কন্ডিশন আছে কেতিয়া কেনসেল কৰিব পাৰে গভৰ্নমেন্ট অফ ইন্ডিয়া OCI। চাওক প্ৰথমটো আপোনালোকে গমে পালে, প্ৰথমটো মই কৈ দিছো যদি তেওঁ OCI খন ফ্ৰড, ফলস ৰিপ্ৰেজেন্টেশন বা concealment of any material fact কৰি পেলাই লয়, কেনসেল কৰি দিব পাৰে। যদি কনস্টিটিউশন অফ ইন্ডিয়াৰ প্ৰতি ডিসএফেকশন দেখায় বা ডিউৰিং ওয়াৰ যত ইন্ডিয়া এংগেজ আছে তাতে শত্ৰুপক্ষৰ পিনে কমিউনিকেট কৰে, বা যদি overseas citizens of India has within 5 years after resignation been sentenced to imprisonment for a term of not less than 2 years, in that case also, and if necessary so to do in interest of sovereignty of India integrity or sovereignty ক্ষেত্ৰত যদি বা security to চাই পেলাই ইন্ডিয়া এনেকুৱা ডিসিশন ল'ব পাৰে যে কি কৰিব পাৰে, গোটে সেন্টেন্সটো পঢ়ি দিছো, if it is necessary to do so in the interest of sovereignty and integrity of India, the security of India, friendly relation of India with any foreign country, or in any interest of any general public, যদি কোনবা একজন মানুহৰ OCI citizenship to cancel কৰিব বিচাৰে কৰিব পাৰে। Okay, in the marriage of an overseas citizen of India card holder has been dissolved by a competent court, যদি তেওঁ marriage খন dissolve কৰি দিয়ে by any competent court, বা has not been dissolved but during the subsistence of such marriage he has been solemnized marriage with any other person, but এনেকুৱা এখন marriage ডিজল্ভ নোহোৱাৰ আগতে তেওঁ বেলেগ এজন মানুহৰ লগত বিবাহপাশত আবদ্ধ হয় তেতিয়া কেনসেল হ'ব পাৰে নেক্সট 27 which of the following act deleted right to property from the list of fundamental rights so now this has become what legal right হয়নে so এই কেইটাটো বহুত পুৰণা এক্ট হ'বই নোৱাৰে 42nd আৰু 44ৰ মাজত আপোনালোকক কনফিউজন লাগিব পাৰে সো 44th কনস্টিটিউশনাল এমেন্ডমেন্ট ইজ কাৰেক্ট সো অৰিজিনালি সাতটা ফান্ডামেন্টাল ৰাইট দিছিলে য'ত ইনক্লুড আছিলে এই দিস ওয়ান মই ভুলকে বোল্ড কৰিছো this should be kept in bold okay oh this should not be kept in bold okay so this has been removed it was removed by 44th Constitutional Amendment Act and now it is a legal right under Article 300 Part 12 of Constitution. Important. Note koi rakhibo. Prothomot ki diছিলে right to equality, freedom, right against exploitation, right to freedom of religion, right to cultural and educational right to constitutional remedies and right to property guti keta asil jetia originally constitution asil pisot eto remove kori dile. Kiman konkan amendment 44th Constitution amendment. 30 number to which of the following fundamental rights are available only to Indian citizens but foreigner karone kuntu fundamental right available nohoy equality before law and equal protection of law equal opportunity in matters of public employment right of elementary education right of minorities to establish and administer education institution you should be aware about which are the fundamental rights that are not available to foreigners which is available to our citizen by Indian citizen but not to foreigners eto monot rakhibo lagibo so here option 2 and 4 is only correct okay this is not correct and this is not correct okay ঠিক আছে fundamental rights available only to citizens but not foreigners prohibition of that means this is available for all except enemy aliens okay eto ako enemy country enemy aliens er kotha koa goise but eto foreigner karone eto ase right eto available hoy ঠিক আছে prohibition of discrimination on the grounds of race religion caste place of birth article 15 article 16 equal opportunity in matters of public employment protection of six right regarding freedom of speech and expression assembly association movement residence and profession under article 19 protection of life and personal liberty article 21 right of minorities to establish and administer educational institution article 30 so these are available only to citizens not to foreigners next which of the following statement is not true the concept of equality before law is British origin is it aru concept of equal protection of law has been drawn from American Constitution boli koise kontu shuddho which are not true I think here equality before law is yeah so both are correct here so actually when I thought this question should be formed as the concept of equality of law is borrowed from American Constitution boli likhibo laisilo that's why I gave it to here but here equality of law is taken from British Constitution and equal protection of law is from the American Constitution here both are correct so if both are correct then none should be false none should be not correct okay yes go to the 30 question the concept of equality before law connotes which of the following key mean kore the equality of treatment under equal circumstances in both in the privileges and conferred and liabilities imposed by the laws the similar application of same laws to all persons who are similarly situated they the like should be treated alike without any discrimination and no person whether rich poor high low or official or non-official is above the law so 3 and 4 are sorry all 2 and 3 only 4 only 2 3 4 only kun keta correct hetu kudise so here 4 only is এক সেকেন্ড সো আমি কোয়েশ্চনটো সুধিছো কনসেপ্ট ইকুয়ালিটি কোনটোৱে বুজায় so equality of treatment under equal circumstances both in the privileges conferred and liability imposed by the laws এইটো 1 নম্বৰ the similar applications of law of the same laws to all persons who are similarly situated. 2 number 2 and the like should be treated alike without any discrimination. And 3 number, these three should be headed under equal protection under law. Only equality before law লগত এটুৱে কনট কৰা আছে, no person is above law. Okay, so the concept equality before law কেৱল কেইটামান আছে, ব্ৰিটিছ অৰিজিন পৰা লোৱা গৈছে। তাতে কি কি আছে, the absence of any special privileges in favor of any person, the equal subjection of all person to the ordinary law of the land administered by ordinary law courts, and no person whether rich or poor, high, low, official, non-official is above the law. So only these three are can be represented by equality before law, and the rest these three are under equal protection. This should be connoted by equal protection of law. Eketa pahori na jao. Okay, which article Supreme Court can issue writs? Ekdom High Court বুলিলে 226 মনত ৰাখিব, এটো হলে Supreme Court মনত ৰাখিব, ঠিক আছে। Article 32. Okay, the Supreme Court under Article 32 and High Courts under 226 can issue writs pasta, habeas corpus, mandamus, prohibition, certiorari, and quo warranto. আৰু এটা কথা আছে, এনেকুৱা সিচুৱেশন যদিও আহা নাই, the Parliament under Article 32 can empower any other courts to issue these writs. So under which article the Parliament is empowered to direct any courts বা empower any other courts to issue writs? It should be under Article 32. Okay, we will move to the question number 32 now. Which of the following is or are true about jurisdiction of Supreme Court as compared to that of the High Court? High Court and Supreme Court or jurisdiction or the comparison hudise tare kuntu true hudise. The Supreme Court can issue writs not only for the enforcement of fundamental rights but also for any other purpose, whereas High Court can issue writs only for the enforcement of fundamental rights. Etu completely bhul, because Supreme Court issue writs only for the enforcement of fundamental rights. For fundamental rights or any other purpose of High Court pare. So first option is not correct. Okay, second, Supreme Court can issue writs against a person or government throughout the territory of India, whereas High Court can issue writs against a person residing or against a government or authority located within its territorial jurisdiction only, or outside its territorial jurisdiction only if the cause of action arises within the territorial jurisdiction. Okay, this is true. A remedy under Article 32 is itself a fundamental right, and hence Supreme Court may not refuse to exercise its jurisdiction. Mane Supreme Court refuse koribo nware its jurisdiction. However, remedy under Article 226 is discretionary, and hence a High Court may refuse to exercise its jurisdiction. So our 2 and 3 are correct here. 2 and 3 are correct here. Okay, Supreme Court can issue writs only for the enforcement of FR, whereas High Courts can issue writs not only for FR, enforcement of FR, but can also for other purpose. Okay, আৰু ইয়াতে এটা বস্তু বহুত ধুনিয়াকৈ লিখা আছে, লাস্ট কোৱেশ্চন টু লাস্ট থিওৰি টু এবাৰ চাই লওক। The remedy under Article 32 is itself a fundamental right. Okay, right of remedy under Article 32, গতিকে এটোৱে যেহেতু ফান্ডামেন্টাল ৰাইট হয়, সেই কাৰণে সুপ্ৰিম কোৰ্টে ৰুইট জুৰিসডিকশন টু refuse koribo নোৱাৰে, may not refuse, কিন্তু 226 is discretionary, Supreme High Court এখানে refuse koribo pare rit jurisdiction to execute koribo karone. গতিকে Article 32 does not merely confer the power to Supreme Court as Article 226 does on a High Court to issue writs for the enforcement of fundamental rights or any other rights as a part of its general jurisdiction. The Supreme Court is thus constituted a defender or guarantor of fundamental rights. Okay, this is the reason. Next we'll go to the next question. Which of the following is true about habeas corpus? It is an order issued by a court to a person who has denied another person to produce the body of, to produce the body of bulile habeas corpus. The writ of habeas corpus can be issued only against public authorities. No, it can be also issued against private authorities also. So here only one is true. Yes, habeas corpus is a Latin term which means to have the body of. It is an order issued by a court to a person who has detained another person to produce the body of letter before it. Courte কৈছে যে তোমালোকে তেওঁক produce কৰা courtত. So habeas corpus. The court then examines the cause and legality of detention. Legal হয় নে নহয় তেওঁৰ detention টো সেইটো courte বিবেচনা কৰিব. It would set the detained person free if detention is found illegal. Illegal হলে এৰি দিবলৈ ক'ব. Thus this read is a bulk work of individual liberty against arbitrary detention. So arbitrary detention or against thought এটা ধুনীয়া safeguard আছে, that is RBA habeas corpus. Writ habeas corpus can be issued against both public authorities as well as private individuals. Okay. Which of the following cases where habeas corpus is not issued? এনেকুৱা কি কথা আছে য'ত habeas corpus বিলাক issue কৰিব নালাগে বা নকৰা নাযায়? If the proceeding is for contempt of legislature or a court, if a detention is outside the jurisdiction of the court, here all the option is correct. So এনেকুৱা কি criteria আছে য'ত habeas corpus issue নহয়? If the detention is lawful, the proceeding is for contempt of legislature or a court, detention is by competent court কৰিলে নহয়, আৰু detention outside the jurisdiction of the court. These 4 points should be remembered for habeas corpus. Next, which of the following cases mandamus is not issued? Mandamus কথা আহিলে. So what do you mean by mandamus? Okay, first up, to enforce the departmental instruction that does not possess any statutory force against a private or individual body, to enforce a contractual obligation against President of India and state governors. Here also all the options are correct. So mandamus means we command. Okay, it is a command issued by a court to a public official. Some public official of যেতিয়া court সোধে to perform his official duties that he has failed or refused to perform. এজন public official যদি entrusted duty to fail কৰিছে, perform কৰিব পৰা নাই বা refuse কৰিছে, মই এটো নকৰো, তেতিয়া কোৰ্টে mandamus দিব পাৰে. Okay, so mandamus cannot be however issued against a private individual or a body to enforce departmental instruction that does not possess any statutory force when the duty is discretionary and not mandatory. যদি mandatory নহয় তেতিয়াও দিব নোৱাৰে, duty যোনটো entrust কৰিছে সেইটো মই মানা নাই, সেইটো যদি mandatory নহয় তেতিয়া কৰিব নোৱাৰে. To enforce a contractual obligation, যদি contractual হয় তেতিয়া নহয়, against the president of India or state governors and against the chief justice of a high court acting in the judicial capacity. So this should be kept in mind. Okay, 36 of them, against which mandamus can be issued now: any public body, corporation, an inferior court and a tribunal. Car against the mandamus issue কৰিব পাৰি. Okay, here all are correct. All are correct. Which of the following is a martial law? So মই এটা আপোনালোকক কাম দিছো, martial law আৰু national emergency, ইয়াৰ difference to please let me know. Okay, so during martial law fundamental right effect হয় বুলি কৈছে, it continues the government and ordinary law course. No, it suspends. During martial law it suspend হৈ যায় government. It imposed on to restore the breakdown of law and order to breakdown of law and order due to any reason, and it imposed in some specific area of the country. So here if you see 2 cannot be correct here, so 1, 3, 4 might be correct. Yes, martial law কি কৰে এটা মনত ৰাখিব, it affects the fundamental rights. Definitely it suspend the government and ordinary law courts. It is very significant and important feature. তো এটোটো আপুনি গমে পালো, it is imposed in specific area of the country আৰু it has no specific provision in constitution, that is it is implicit. So these are the points that should be remembered. But during, this is a feature of national emergency, Okay, next cycle, which of the following is not true about DPSP by directive policy of state policy, directive principle of state policy? These are justiciable, that is they are legally enforceable by the courts in case of their violation. Okay, they aimed at establishing political democracy in the country. The courts cannot declare a law violative if any directive principle as unconstitutional and invalid. Okay, so they require legislation for their implement. So 2, 3, 4 are here option, I think 1 and 2. Yes, this is not correct also. the court can declare a law violative of the DPSP as unconstitutional and invalid. So here 1 and 2 are correct only. Okay, so DPSP kotha ketaman jani lo. These are positive as they require the state to do certain things. These are non-justiciable. Mane yet ki this is justiciable. This is not true. They are not legally enforceable by the court for their violation. But a violation hole court go lam jai. They aim at establishing social and economic democracy of the country. This is also an important point. They have moral and political sanction. They promote welfare of the community, hence they are socialitarian and socialistic. They require legislation for implementation. Without legislation, they cannot be implemented. The courts cannot declare a law violative of any DPSP as unconstitutional, okay, and invalid. However, they can uphold the validity of law on the ground that it was enacted to give effect to a directive. So okay. So I have হেতুৱে মই ভুল কৰিছো পৰীক্ষাত আপোনালোকে ভুল নকৰিব this should be not true কোনটো true নহয় সুধিছে মই true হৈ পেলাই চাই আছো so এইটো true নহয় definitely justice these are not non justiciable আৰু এইটো political democracy নহয় this should be point number 2 social and economic democracy. This is political democracy should be related to the fundamental rights, okay, and justiciable is also related to the fundamental rights. ঠিক আছে আৰু courts cannot declare a law violative of any, okay, yes, and this is true so not true hobo 1 and 2 are not true, okay. So very sometimes amar keneke bhul hoy dekhise ne, so you don't do this mistake in the examination, okay. 39 কোনটো আৰ্টিকলে এই ওপৰৰ কোডটো মানে ৰিপ্ৰেজেন্ট কৰে সুধিছে it shall be the endeavor of every state and every local authority within the state to provide adequate facilities for instruction in mother tongue as the primary state of education to children belonging to linguistic minority group. Very important. So please remember some articles. This is article 350A. এই গুটেকেটা আর্টিকেল পারিলে 1 2 these two articles are also important আপোনালোকে চাই লব article 335 and 351 335 এ কি বুজায় মোক জনাব আৰু 351 এ কি বুজায় মোক জনাব ওকে মাদাৰ টাঙৰ ইনস্ট্ৰাকশনৰ কথা কি দিয়া হৈছে article 358 part 17 ত উল্লেখ কৰা আছে ঠিক আছে এটা একদম ডাইৰেক্টলি কিছুমানে কয় part 7 কেনেকা মনত ৰাখিলে so you know some things you need to be remembered. This is 10, this is 15, okay, aru yar pisot jimane lagi jay 16 and 17 like that, okay. So which of the following is wrongly matched? Article 44 Uniform Civil Code, 45 provisions for early childhood care and education to children below 6 years, article 46 promotion of educational and economic interest of scheduled castes, tribes and other sections, article duty of states 47 এ বুজাই বুলি কৈছে duty of states to raise their develop nutrition and standard of living and improve public health. So here none is not correct, incorrect. Everybody is correctly matched, everyone is correctly matched here, okay. So next, which of the following is possible regarding amendment of the constitution? amendment this আৰু ইয়াত আছে okay প্ৰথম কোৱেশ্চনটোৰ পৰা ইয়াত ডিফাৰেন্সটো কি মই ইয়াত আৰ্টিকল 368 ৰ কথা সোধা নাই মই ইয়াত কৰিছো কি কনস্টিটিউশনত এমেন্ডমেন্ট কৰিব কাৰণে কি কি ধৰণৰ পদক্ষেপ ল'ব পাৰি ইয়াতে যদি চাই গুটে কেটা পাৰে স্পেশাল মেজৰিটি পাৰে simple majority পাৰে simple majority by parliament special majority by the parliament amendment by simple majority of the parliament and ratification of the half of the states but here this should be special majority again খৰু খৰু টার্ম বিলাক মনত ৰাখিব so here 1 and 2 only correct yes this should be special majority কৰিব পাৰে কিন্তু শব্দ বিলাকো মনত ৰাখিব simpleness special কথা কৈছে so the constitution can be amended in 3 ways okay amendment by simple majority of the parliament amendment by special majority of parliament and amendment by special majority by parliament and ratification of half of this okay 42 Formation of new states, alteration of new states, boundaries, names of existing states can be done by, so simple majority পাৰে নে, special majority of the parliament পাৰে নে, simple majority plus half of the ratification of state পাৰে, এটো ভুলে আপোনালোকে গমে পাইছে, presidential order নহয়, তো কোনটোৰে পাৰে, so it can be done by simple majority only. Very important, মনত ৰাখিব, stateৰ কথা আহিছে কাৰণে বহুতে half of the special majority plus half of the ratification of states বুলি লিখে. Okay, a number of provisions in constitution that can be amended by simple majority of the two houses of the parliament outside the scope of 368. These provisions are simple majority outside the scope of 368. Simple majority ko pare ki admission and establishment of new states ketaman important, etu sai lobo, abolition of creation of legislative council of state, alteration of boundaries, names, etc. A privileges of parliament and its member and its committees keta sabo, then citizenship acquisition and termination ebilak ahibo pare, elections to parliament and state legislature is one important point. Ebar delimitation of kotha ahibo pare, delimitation of constitutional procedure bilak change korar khetrot kuntu majority lobo lage. Okay, fifth schedule and sixth schedule, very important, very important, so this all should be kept in mind jiman pare. Okay, 43, amendment of provision of distribution of legislative powers between union and states can be done by the union or state or power keta, division of the distribution of legislative power between union and states, division of power could be tar jonto procedure ase jeto change koribo laga hol tetia ki koribo lagibo, this should be a question ke bolise, this should be special. Okay, this should be special and this should be also special, so this could be special. So this could be done by amendment by special majority of parliament and the ratification of half of the legislature. Yare ketuman aru ketuman ki koribo pare, election of parliament, president and its manner, extent of the executive power of the union and states, supreme court and high courts, distribution of legislative power between states and union state. Eto eta important bostu, eto eta important fact. 7th schedule, representation of states in parliament, this is also important. Power of parliament to amend the constitution and its procedure, this is also very important. This could be done by special majority of the parliament and ratification of half of the state legislature. Next, basic feature of constitution kun keta hoy boli koise, if you see all of the following are included in the basic structure of constitution. So I have also given some examples of basic structure of constitution like separation of power between legislature, executive and judiciary, unity and integrity, principle of equality, free and fair election, independent of judiciary, then principles underlying the fundamental right, welfare state. These are after various judgments, finally these are included in as a basic structure of constitution. So these are some examples. Next, we are going to the 45 number question. Constitution of India provides parliamentary form form of government in center only, state level only, both center and states only, center, states and panchayat. Here it should be both center and state. Okay, next we will go to the 46 number question. Which of the following articles deals with parliamentary system of government at center level? The center level or kotha kudise kun duta article represent koribo pare boli koise. Which of the following articles deals with parliamentary system of government? 74, 75, 163 are both 74 and 75. So this should be D. Karan for 74 e ki diye, provides a council of ministers headed by PM to aid and advise the president, and 75 e ki koy, ministers are collectively responsible for parliament in general and to the Lok Sabha in particular. So article 163 and 164 or important hoy, these deal with parliamentary system of states only. Okay, 163 or 164 to complete তথ্য কেইটা মোক কমেন্টত জনাবো কি ৰিপ্ৰেজেন্ট কৰে. Okay, next we'll go to the 47 number questions. Which of the following is main feature of parliamentary system of government? If you have gone through this chapter, very important chapter, very important chapter, please revise koribo. So here executive is responsible for legislature for its policies and acts should be the main feature. C. Okay, next 48 number question. Which of the following scholar called the parliamentary system of government as cabinet system? This is Ivor Jennings. This should be also direct factual question. Next, which of the following is not represented by parliamentary system? Kuntu represent nokore? Dual executive, political homogeneity, single citizenship, or fusion of power. So here, single membership is not represented by parliamentary system. Features kini ki hoy parliamentary system or dual executive, majority party rule, collective responsibility, political homogeneity, double membership. Okay, double, not single. Leadership. This should be presidential system or অন্তর্ভুক্ত হয় presidential system, not in parliamentary system. Dissolution of lower house, fusion of powers. Okay, so next we are going to the presidential system. Kuntu nohoy koise represent nokore? Single executive, presidential and legislature elected separately for a fixed term, non responsibility, dissolution of lower house. Here dissolution of lower house একটু গমে পাইছে already comes under parliamentary system. এতিয়া আমি presidential system যদি আপনি চাই then you will get to know this single membership is here. Okay, so single executive, presidential and legislature elected by separately for a fixed term, non-responsibility, political homogeneity may not exist here also. Domination of president, single membership, no dissolution of lower house. It will main at a distinguished point, main distinguished point. Okay, parliamentary and presidential, separation of powers, domination of president. Okay, next 51. Which of the following is not a federal features of constitution of India? Aquamic B issue. Dual polity, written constitution, division of powers, states are non indestructible. Okay, this is not correct. This is unitary. So federal features কেইটামান আপোনালোকে মনত ৰাখিব: independent judiciary, bicameralism, supremacy of constitution, rigid constitution, dual polity, written constitution and division of powers. Next, unitary features কেইটামানৰ কথা কৈছো কোনটো নহয়: strong center, written constitution, division of powers, states non destructible. So division of powers is under federal features. So unitary features কেইটামান: strong center, written constitution, single constitution, states not indestructible, flexibility of constitution and no equality of state representation. So part 2 is over now. So if you want part 3 then let me know. Okay, so please like, comment, share and subscribe our YouTube channel. Then we can bring the part 3 of this series, that is Polity Marathon. Thank you and have a nice day.